Greetings at Cheating Story Lab. At 9:47 a.m. during the culmination of our divorce proceedings, my legal representative sent a solitary text. My mother had unexpectedly entered the courtroom, bearing the authentic trust documents. This turn of events promises to be captivating. I spent 3 readings of that message in my vehicle parked outside the courthouse, having endured Heather's efforts to claim half of my possessions for 18 months. Her legal adversary, a ruthless lawyer named Brennan known for wringing blood from a stone, had been crafting a tale during this time frame that portrayed me as a pampered trust fund recipient contributing nothing to our matrimonial life. Their narrative painted me as a shiftless freeloader, benefiting from my mother's generational wealth, while Heather propelled us forward with her ambition. However, there was some truth to their story, which made the impending occurrence so serendipitous. I wish to rewind 6 years to shed light on this intricate plot. At a financial networking gathering in 2018, I encountered Heather. I was 31, employed as a portfolio analyst at a medium-sized investment firm, and though not particularly glamorous, the job offered stability. She, on the other hand, was 29, charismatic and thriving in pharmaceutical sales, her energy brightening every space she inhabited. Our initial conversation extended to 3 hours, during which she inquired about my career, aspirations, and family. I admired her apparent attentiveness. In the 3rd month of our relationship, I mentioned my trust fund. This wasn't for boasting. It arose organically while discussing my mother's long-standing financial planning profession. Over 40 years, Dorothy had served as a wealth manager, and when I turned 25, she established a trust fund worth $2.8 million. The fund was structured to grow gradually, providing me with both a gift and a means of learning the principles she'd spent decades perfecting. Heather reacted positively but cautiously to this revelation. "That's remarkable that your mom took such initiative for you," she said. "You seem to have an exceptional bond." "Not quite. More of a harmonious dynamic, not analytical. We tied the knot 14 months after that in a simple ceremony reflecting our shared desires. For the initial 2 years, things truly were splendid. We acquired a humble abode. I used trust dividends for the down payment while she took care of furnishings and renovations with her sales commissions. Our travels were numerous, and we occasionally discussed having children. She never pressured me regarding the trust fund nor suggested dipping into the principal for any reason. However, year 3 brought minor alterations. Heather started logging longer work hours and more frequent trips for her pharmaceutical territory. When she was home, she seemed perpetually preoccupied with her phone. I attributed these changes to her expressed career aspirations, aiming for a director-level position, but our previously effortless conversations turned transactional. "Did you pay the electricity bill? Your mother called again. I'll be in Atlanta until Thursday." In our 4th year together, we shared a mortgage and lived as roommates. She frequently stayed up late on her laptop in the spare room, while I often found her absent for early business meetings. The growing spatial separation reflected the deepening emotional rift between us. When I proposed marriage counseling, she retorted, "I don't believe talking to a stranger can mend your lack of ambition." Her words lingered with me. Lacking ambition was my alleged flaw. Despite having a stable job, shouldering an equal share of household expenses, and managing my trust fund judiciously, I found myself becoming an impediment in her path. The fateful October morning arrived when Heather stepped into the kitchen dressed for a run, but it was evident she hadn't been jogging. Her composed expression hinted at the impending upheaval. "I want a divorce," she announced. "I have already consulted an attorney." "I should consider doing the same," she added. Without expressing feelings or explanations, she opted for a straightforward cut. "May we discuss this matter?" I inquired. "What transpired? There was no occurrence, Grant. We grew apart, people evolve, I have evolved, you haven't." She picked up her keys from the counter. "My legal representative will forward paperwork to whoever you engage. I'm residing at a hotel until we work out the details." She departed just like that. 4 years of marriage were abruptly concluded in 90 seconds while my coffee maker signaled its completion in the background. That afternoon, I phoned my mother. Dorothy heard the entire narrative without interruption, a talent she had honed over many decades of handling distressed clients. "I'm sorry, dear," she eventually said. "I understand this is painful, but I require something from you before you engage a lawyer, before you react to anything her legal representative sends. Before making any decisions about assets, call me first." "Request a call from you first, Grant." Your mother's voice held an uncommon seriousness. "Contact me prior to making any decisions, please," I agreed. 3 days passed before Heather's lawyer forwarded a tentative settlement plan. It was relentless. She demanded the house despite my initial deposit. She sought half of my retirement savings. Moreover, she claimed $1.5 million from my trust fund, precisely half of what she calculated it to be, as recompense for financial burdens endured during the marriage in aid of a household that nurtured a career with limited earning potential. I scrutinized that phrase repeatedly. She was asserting her contribution. The one who'd scoffed at my aspirations now contended she'd been my financial benefactor. I reached out to my mother. "Recite the precise terms regarding the trust fund," Dorothy instructed. I recited them as she had asked. A lengthy pause ensued, followed by, "All right, here's the plan. You will engage Rita Calabrese. I will provide you with her contact details. Inform Rita of all details, but remember, you are going. Emphasize your intention for fairness and transparency, not concealing assets. Let Heather's lawyer believe this is a straightforward, equitable division case." "Mom, what? Do you have faith in me?" "You did. I always had." I retained Rita, a seasoned family law attorney in her 50s with gray hair styled as armor and eyes that missed little. During our initial consultation, I disclosed the entire situation. The trust fund, Heather's requests, my mother's advice to delay. Rita leaned back in her chair. "You are aware this is Dorothy Novick we're dealing with? Every estate attorney in this city knows Dorothy Novick. If she told you to wait, then we shall." During this period, we put forth a balanced response to their proposition, avoiding both relinquishing the trust fund and being overly defensive about it. We approached the situation as if it were any ordinary negotiation. For the following 4 months, Brennan and Rita and I solely corresponded through our lawyers regarding proposals. I transitioned into a temporary rental dwelling, while she remained in our home that increasingly felt like hers due to the extensive redesigns. Meanwhile, something intriguing was unfolding behind closed doors. My mother contacted me every fortnight with the same query. "Has her legal representative filed for financial disclosure yet?" For 4 months, the answer remained the same: no. They were merely positing demands without formally asking for documentation of assets. However, in the 5th month, they finally submitted such a request. Brennan demanded comprehensive details about the trust fund, account records, transaction history, current appraisal, and the initial documents that designated my mother as the grantor and me as the beneficiary. Dorothy replied, "Excellent," upon hearing the news. "Now we take action. Inform Rita to supply everything they requested, every single document, ensuring complete transparency. Won't that just provide them with ammunition? Grant, do you remember when I set up that trust fund? Your 25th birthday, December 2012, and do you recall when I dissolved it?" My thoughts faltered. "What?" "January 2022. 14 months after you married Heather, 2 years before she filed for divorce. The trust fund she's demanding half of no longer exists for over 2 years. The realization hit me like a wave. You transferred the assets elsewhere, into a collection of irrevocable trusts and investment vehicles that are legally distinct from marital property. It's all properly documented, legal, executed with competent legal counsel. The original trust she's obsessed with, empty, has been for 24 months. I was anticipating her lawyer to officially ask for the necessary documents so we could supply them during the discovery phase and observe their reaction as they grapple with what they've been chasing for 18 months. She's been preparing a case to claim half of something that doesn't exist in the form they assume, precisely. Incidentally, her attorney has been charging her for devising a plan centered on an asset that no longer exists in the way they think it does. Rita will provide comprehensive documentation detailing the trust's dissolution, legal transfers, and timeline. All these actions were completed before Heather filed for divorce, which implies they weren't carried out to evade marital property division. Instead, it was routine estate restructuring that I, as the grantor, had the legal authority to execute. I listened to her voice on the phone, realizing with growing wonder, "How did you know?" 18 months after our marriage, how did you know to take these actions?" Dorothy's tone grew gentle. Without definitive knowledge, I observed subtle indications in her queries about the trust framework at Thanksgiving that year, her interest in understanding distribution schedules, and whether you held full control. She was tracing it, dear. Perhaps not consciously, perhaps not with harmful intentions initially, but she was inventorying assets. Consequently, acting as any competent wealth manager would, I reorganized the structure to safeguard your interests. Does this mean I lose access to the funds? No. I remain the sole beneficiary of the newly established structures, but they're shielded from creditors, legal disputes, and marital proceedings. The funds still belong to you. She merely cannot access them. 3 days later, we filed our response to discovery. Rita included all documents Brennan requested. The original 2012 trust formation papers, 12 years of account statements, and the January 2022 dissolution documents signed by Dorothy as grantor, formally ending the trust and transferring assets to new entities outside of my direct ownership. Rita stated that Brennan contacted her shortly after receiving the package. She mentioned he was professional, but his tone hinted otherwise. He's been devising a whole strategy for the case involving the trust fund. However, he must now inform his client that the asset she has been insisting on is non-existent, and he has spent months and tens of thousands of her money chasing a phantom. 2 weeks later, the court issued a motion to classify the asset transfer as a fraudulent conveyance meant to conceal marital property from equitable division. Rita clarified that they're arguing you knew the divorce was imminent and moved assets to hide them, but the timeline contradicts this claim. The transfers took place 14 months after your marriage and 2 years before she filed. It would require psychic abilities to make a judge believe otherwise. Dorothy Novick is one of the highly esteemed wealth managers in the state, with impeccable documentation. The transfers were routine estate planning steps, carried out correctly and reported appropriately. Unless Brennan can demonstrate collusion between you and your mother in 2022 to safeguard assets prior to a divorce filed in 2024, he has no case. The hearing is set for March 14, 2025. 6 months of legal strategies, discovery, motions, and countermotions culminate in this moment. I didn't sleep the previous night, not due to apprehension, as I trusted Rita and your mother's planning, but out of excitement. For 18 months, Heather has been dictating the story. She was portrayed as the ambitious one held back by an unambitious spouse. She was depicted as a financially martyred individual entitled to compensation. She was presented as a victim of a man hiding behind inherited wealth. Tomorrow, this narrative will crumble. I arrived at the courthouse at 8:30 a.m. Rita was already there, going over notes on a bench outside the courtroom. "Your mother texted me," she said. "She's coming. She intends to be present during the trust discussion." At 9:47 a.m., your mother indicated her arrival via text. She wishes to attend the discourse regarding the trust. Dorothy strolled into the courthouse with a familiar leather portfolio from her office, catching my eye as she approached and patted my shoulder. "I'm hanging in there," I said, admitting to feeling ready for the ordeal to end. She nodded, assuring me it would soon be over. The modestly sized courtroom, paneled with wood and imbued with formality, belonged to Judge Casalano. Heather, sitting at the plaintiff's table alongside Brennan in a pricey navy suit, avoided eye contact as I entered. Dressing the room, Judge Casalano, a woman of around 60 with reading glasses on a chain and an experienced demeanor, commenced the proceedings. "Today we discuss final asset division in the case of Grant Novick versus Heather Novick," she started. "From what I gather, the main point of contention revolves around a trust fund created by the defendant's mother. Mr. Brennan, you submitted a motion alleging fraudulent conveyance. Explain your stance." Confident and polished, Brennan stood to explain his position. "Your Honor, it is stated that the defendant's mother established a trust fund worth $3 million for her son in 2012, which was considered a marital asset during the marriage. Income from this trust was utilized for shared expenses, such as the down payment on the matrimonial home. However, Dorothy Novick dismantled this trust and moved the assets into protective structures in January 2022, making them inaccessible for division in marital property. The argument is that this transfer was executed with the foresight of divorce, which was not filed until April 2024, a span of 28 months later. Judge Casalano addressed Rita. "Ms. Calabrese," Rita stood composed and systematic. "Your Honor, to accept the plaintiff's argument, we must assume that Mr. Novick and his mother colluded in January 2022 to safeguard assets from a divorce not yet filed in April 2024. The trust dissolution was a routine part of estate planning, legally executed and reported to the IRS. Dorothy Novick, a long-established wealth manager and trust grantor for 4 decades, remodeled the trust for tax optimization and asset safeguarding purposes that were entirely independent of her son's upcoming marriage. The accuser has presented no proof of collusion, no evidence suggesting divorce was envisioned at the time of the transfer, and no evidence of deceit." Judge Casalano addressed Brennan. "Do you possess evidence indicating that Mr. Novick or his mother were aware of an impending divorce in January 2022? The timing appears questionable, Your Honor." "Questionable isn't proof, Mr. Brennan. Do you have communications, documents, or testimonies suggesting they knew?" Brennan hesitated. No, Your Honor, but then your motion for fraudulent transfer is dismissed. The judge made a note. The trust dissolution happened before any divorce filing and was carried out by the grantor with full legal authority over her own estate planning tools, exhibiting no signs of fraud. The restructured assets were exempt from division of marital property. I observed Heather's facial expression, her jaw stiffened. Brennan murmured something to her, but she firmly shook her head. Your Honor, Brennan persisted, we kindly ask Mrs. Dorothy Novick to testify about her decision-making process when I'm present, my mother declared from the gallery, causing all eyes to turn. Dorothy rose, walked through the gate separating the gallery from the council tables, and approached the bench. Your Honor, I am Dorothy Novick. I created the trust and subsequently dissolved it. If the court requires further insight into my rationale, I stand ready to provide it. Judge Casolano seemed taken aback but motioned to the witness stand. Please do. My mother was administered the oath. She sat with the same poised confidence she displayed in every client meeting. Mrs. Novick, Judge Casolano said, elucidate why you dismantled the trust in January 2022. I request 3 reasons, Your Honor. The initial trust setup worked well for a single beneficiary in his 20s, but became less effective as he progressed into his 30s with diverse financial requirements. In my role as a wealth manager, I advocate clients to periodically revise their estate arrangements to safeguard against possible creditors, lawsuits, and financial hazards. Furthermore, a key issue pertinent to this courtroom was the ambiguity regarding Heather's involvement in my son's assets. The courtroom fell silent upon hearing this. Heather's complexion paled, prompting Judge Casolano to lean forward for clarification. Could you elucidate on that last point? On Thanksgiving 2021, Heather displayed keen interest in the trust structure, inquiring about the distribution of principal and growth, accessibility of funds, any restrictions, decision-making powers over investments, my ability to dissolve the trust, and whether it was immutable in its initial form, Dorothy replied, producing documents from her portfolio. After the discussion, I jotted down observations as I perceived the queries were reconnaissance rather than casual curiosity. 2 months later, I consulted estate lawyers and restructured my assets to secure my son's inheritance. During the trial, Brennan argued, Your Honor, this is speculation. Dorothy calmly replied, Maybe Mrs. Novick is attributing malicious intent to innocent questions, but I present documentation that could offer context. She passed documents to the court officer who handed them to the judge. The documents were phone records from December 2021, revealing Heather contacted 3 different divorce attorneys in a single month following our Thanksgiving conversation. However, none of these consultations led to retained counsel at that time, suggesting she was exploring divorce options 16 months before filing. This revelation caused an uproar in the courtroom. Judge Casolano banged her gavel, and Heather leaned over to Brennan, whispering urgently, How did you obtain these records? The judge then asked Dorothy for clarification. The attorney consultation logs, the court noted, can be obtained during divorce proceedings. I made the request for records 3 months ago as part of routine investigation. Judge Casolano reviewed the documents. Mr. Brennan, the judge asked, were you aware that your client consulted with divorce attorneys in December 2021? I didn't know about that specific timeline, Your Honor. Turning to Heather, the judge stated, Ms. Novick, you consulted with divorce attorneys 16 months before filing, 2 months after seeking detailed information from your mother-in-law about your husband's trust fund structure. Heather sounded faint. I was just exploring options because our marriage wasn't doing well. That doesn't necessarily mean, the judge interrupted. It implies that Mrs. Dorothy Novick's concerns regarding your interest in the trust fund were valid. It suggests that the dissolution of the trust in January 2022 was a reasonable reaction to what seemed like asset scrutiny. The judge addressed Rita, questioning Heather's allegation that the dissolution aimed to deceive property division. What alternative do you suggest for total asset distribution? Rita proposed our plan. We propose splitting the house equity equally, maintaining individual retirement accounts, and granting Heather a smaller settlement reflecting her share of joint household expenses during marriage. Judge Casolano agreed, making some adjustments. Decision rendered. The house will be sold with profits split 60-40 in my favor due to initial down payment. Retirement funds remain separate. No trust fund distribution case closed. Heather remained still as the judge pronounced the verdict. Brennan collected his documents, evidently conceding defeat. Upon dismissal, I struggled slightly. Dorothy offered support. Let's leave. In the corridor outside, I finally asked my burning question. What was the total expense for everything restructuring, legal fees for investigations into attorney consultations, and so on? It amounted to approximately $85,000 over a period of 2 years. However, your trust fund gained more than that in growth during the same time frame. View it as an investment in your future and a lesson about safeguarding important things. She smiled. She invested 18 months and roughly $200,000 in legal fees pursuing this. But she didn't gain anything but debt and the realization that she wasn't as clever as she believed. We stepped out of the courthouse into March sunlight. I felt noticeably lighter for the first time in 2 years. 3 months later, the house was sold, and I received my share of the equity, allowing me to move into a better apartment. As far as I know, Heather moved out of state. According to mutual friends, Brennan sent her a final bill, which I heard through legal circles she's still paying off. Dorothy and I have been having lunch together every Sunday now. She's instructing me on complex wealth preservation tactics, not because they are relevant to my job, but because she wants me to grasp what she spent 4 decades mastering. She explained last month over Thai cuisine that the trust fund was more about education than money. It taught lessons such as wealth requires defense, people's true nature often surfaces when assets are involved, and one should always have an advisor who anticipates future moves. You were strategizing 3 steps ahead before I even realized there was a game, she remarked. That's what mothers do, dear. They perceive the game long before their children understand it exists. The ultimate paradox. The new wealth structures Dorothy devised not only surpassed the original trust in growth, but also offered superior investment options, reduced tax liability, and enhanced security. While she spent 18 months battling for half of something that no longer existed, the actual assets, reorganized, safeguarded, and flourishing, were never part of the equation at all during this struggle. She sought $1.5 million from her $3 million trust fund. The judge granted it to her. However, the money in the fund had already been exhausted. The woman responsible for establishing, maintaining, and safeguarding that fund was my mother, who perceived the danger far ahead of me and orchestrated every move while I was still grappling with the game's fundamentals. Revenge doesn't always need to be sensational. Sometimes it's simply a matter of numbers, timing, and a mother who spent 4 decades mastering protection strategies for what truly matters. The story concludes here.